This memorandum provides a strictly objective, verifiable, and legal definition-based analysis of the term person in U.S. law, the 14th Amendment's application to citizenship, historical legislative developments, Naturalization Acts, foundational case law, the difference between a sovereign individual under classical constitutional principles and the sovereign citizen position rejected by courts. No language herein reflects bias, interpretation, or conjecture. All statements are supported by citations to statutes, court opinions, and historical records. A. Statutory definitions. 126 USC Section 7701-1- Internal Revenue Code. The term person shall be construed to mean and include an individual, a trust, estate, partnership, association, company, or corporation. 2. 8 USC Section 1101-1B3, Immigration and Nationality Act. The term person means an individual or an organization. 31 USC Section 1, General Provisions. In determining the meaning of any act of Congress, unless the context indicates otherwise, the words person and whoever include corporations, companies, associations, firms, partnerships, societies, and joint stock companies, as well as individuals. Conclusion. The word person is a legal term of art used to describe both natural and artificial legal entities. It does not refer exclusively to any racial, ethnic, or economic class. It is neutral, used to ensure laws apply uniformly to entities capable of legal rights and duties. Textual authority, U.S. Constitution Amendment, 14, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Key case law interpretations. United States versus Wong, Kim Ark, 169 U.S. 649, 1898. Confirmed that birth within U.S. territory grants citizenship under the 14th Amendment. Slaughterhouse cases, 83 U.S. 36, 1873. Distinguished between state and federal citizenship, but did not restrict federal citizenship by race. Brown versus Board of Education, 347 U.S. 483, 1954, confirmed the equal protection of all persons under the 14th Amendment regardless of race. Afroyim versus Rusk, 387 U.S. 253, 1967, affirmed that U.S. citizenship cannot be involuntarily revoked once granted. Conclusion. The 14th Amendment establishes a uniform baseline of citizenship. Its use of the term person is inclusive and race neutral. Naturalization Act of 1790 restricted naturalization to free white persons of good character. Naturalization Act of 1870 expanded eligibility to aliens of African nativity and persons of African descent. Immigration and Nationality Act of 1952, McCarran-Walter Act, eliminated racial restrictions entirely. C. 8 USC sections 1,400, 1 through 1,452. Conclusion. Earlier restrictions based on race were repealed. U.S. citizenship law is now race neutral, codified in statute and confirmed by case law. Federal and state courts have uniformly rejected sovereign citizen legal theories as frivolous, unsupported by law, and a waste of judicial resources. Notable cases: United States versus Banabe, 654, F.3D 753, 767, 7th Circuit, 2011. Sovereign citizen arguments should be rejected summarily, however they are presented. United States, Force Jagim, 978 F. Andra upplagan 1032, 8:e cirkusen. 1992. Sovereign citizen defenses are completely without merit. Bryant v. Washington Mutual Bank, 524, F. Subsecond District 753, Western District, Virginia, 2007. Being a state citizen does not exempt one from federal laws. Sovereign individual, classical constitutional theory. A sovereign individual is one who recognizes that individual rights are inherent, not granted by government, exercises autonomy within the boundaries of law, e.g., First, Ninth, and 10th Amendments, is subject to voluntary social compact theory, as outlined by Locke, Madison, and Jefferson, may choose lawful civil disobedience while accepting lawful consequences, is protected by common law and constitutional due process. This concept is recognized in constitutional history. Yick Wo v. Hopkins, 118 U.S., 356, 1886. Sovereignty remains with the people. Chisholm v. Georgia, 2 U.S. 419, 1793. The people are sovereign. Sovereign citizen, modern movement. The sovereign citizen movement is a pseudo-legal ideology that asserts individuals are not subject to federal law. Statutory laws apply only to persons who consent. Birth certificates create a legal straw man or corporate fiction. Courts have no jurisdiction unless consented to. These claims are false and repeatedly rejected. McElvain v's United States, 985 F. Subsecond District 1166, MD, Alabama, 2013, dismissed claims based on living man status and sovereign citizen theory. United States versus Perkins, 2012, WL 6201180, DeMont, December 12, 2012, reaffirmed jurisdiction over individuals regardless of sovereign citizen defenses. The term person in law is a neutral term of legal status, not a racial designation. The 14th Amendment provides a constitutional foundation for citizenship, applicable to all persons, including natural and naturalized citizens, irrespective of ancestry or artificial status. The sovereign individual tradition, rooted in classical liberalism and natural rights, is lawfully recognized and forms part of America's founding ethos. In contrast, the sovereign citizen movement is a non-legal ideology dismissed uniformly by judicial systems across the United States. Public understanding of citizenship, legal definitions, and constitutional rights should be informed strictly by verifiable legal sources and not extra-legal ideologies or pseudo-legal constructs. This memo may be used for legal education, constitutional training, or government publication purposes to distinguish factual citizenship principles from misinformation.